I call Dennis O'Rourke.
Mr Speaker, I want to go through the stated aims of the original bill and comment on the outcomes in these 10 amendment bills. Firstly, the aim was to encourage faster and less expensive resolution for broken families who have issues concerning the custody and care of children to resolve, by requiring parties to participate in the new FDR process instead of having to go to the court for determination unless necessary, especially in cases of family violence. Mr Speaker, this had potential but has been spoiled by the many other provisions of the reforms. Secondly, lawyers were not to represent parties in FDR but may give initial advice if on legal aid or paid for privately, of course. The problem here is that too few people who will need it will qualify for legal aid. The threshold, Mr Speaker, is far too tough. So some will be well supported, those who do qualify and those who can afford to pay for a lawyer privately. But there will be a large number who fall between these two situations, and that's the problem. Thirdly, the family court was to focus on matters genuinely needing a court decision where protection of vulnerable people and children would be prioritised. Now, I have no problem with that, but has this been achieved in the bill? The real issue is whether the alternative FDR system, as set up in the bill, has been well enough set up to take the court's place. And I have no confidence that that will be the case for far too many people. Fourthly, parties were to take responsibility for their own arrangements concerning the care of children where possible. That sounds fine. But the issue here is not so much a statement of principle of self-responsibility. It is the fact that people do need help through these systems. The worst aspect of these reforms is that the government is not funding sufficient counselling before a dispute matures to make self-responsibility practicable as a way of proceeding in far too many cases. And as I've already said, the legal aid to be provided the legal aid test is far too tough. The point is that there are areas of significant legal challenge to be dealt with by parties who cannot be expected to fully understand them. Too many for the government's no lawyer provisions in these amendment bills. The government just doesn't care about this, Mr Speaker. It thinks saving money is more important. This is a second-class justice approach, and the government cannot now pretend that it is anything else. Fifthly, the original intention was to try to reduce the exacerbation of family disputes by making it not so easy to get to court, because legal proceedings often make relationships worse, but with the court still there as a backstop. Not only is it not so easy to get to the court now, but there are significant barriers to parties as to the system as a whole. As it has turned out, the legislation will exacerbate rather than reduce areas where there will be a power imbalance by parties being forced into processes where one party will have the advantage of representation or advice and another will not. This is not an improved system, it is a worse one. It is all very well to have a simplified and cheaper system, but this will be at the expense of the equality of the parties in the system. And it therefore risks compromising the system as a whole, reducing the success rate and damaging the outcomes for the very people, the children, whose interests the legislation says are to be paramount. Sixthly, the legislation would seek to be more responsive to victims of family violence. The legislation does expand the definition of psychological abuse, and it increases maximum sentences for this from 2 to 3 years, and improves delivery of mandatory non-violence programs. Mr Speaker, these part of the reforms are worthwhile, probably the only part in that category. 7, the government was open about its main intention to make family court more efficient and cost-effective. It was always clear that the major objective was in fact to save money, and this permeates the reforms from start to finish. Sadly, this will, as I've already said, be at the expense of a fair and effective system which parties will have genuine access to and be able to use effectively. Eighth and last, the last of the stated aims was to speed up court applications by reducing the court's rapidly increasing workload. The reforms, Mr. Speaker, may well speed up the family court's workload, but they will not necessarily speed up the system for the parties overall. In the end, despite a very large number of amendments having been made to the bill as originally introduced, our reservations in New Zealand First and our concerns have certainly not been met. By far the biggest concern for us was the reduction in the use of lawyers for the parties and lawyers appointed to represent the children. And secondly, the reduction in the availability of legal aid, now available only to a limited degree prior to but not during any mandated dispute resolution process, and if the dispute goes before a judge. New Zealand First does not agree to penny pinching of that kind, resulting in a lack of adequate legal representation and with it severely reduced legal aid entitlements. As a fundamental principle of justice, parties with a reasonable need should decide if they need a lawyer, not regulations. Legal aid for advice before family dispute resolution should be free for those under the income threshold for legal aid, estimated at about 60% of participants. So most parties are already legally aided out of necessity. But the availability of legal aid should not be the basis upon which parties decide if they will have a lawyer or not. And there will, of course, be about 40% who may be unable to cope without legal aid. While FDR is likely to be less expensive than hiring a lawyer and proceeding to a defended hearing in the court, these requirements are so tough that many people will simply not get a lawyer when they really need one. So there is a real problem of power imbalances being created as a result. These reductions in legal representation and legal aid are the main reason for New Zealand First opposing the legislation. And these reductions are likely to be a false economy anyway, because the costs in other areas are likely to increase. Fundamentally, if the quality of the process is compromised, the resolution will be illusory, resulting in another dispute later. Another particular reason for opposition is that the bill prohibits the court appointing a lawyer to represent the child unless it is necessary. The concern is that lawyers would no longer be involved in the initial stages of proceedings under the Care of Children Act. The problem is that the bill requires the court to have, quote, concerns for the safety or well-being of the child and consider an appointment necessary. That's far too tough. It should be the other way round. The court should appoint a lawyer unless it finds that it is unnecessary to do so. The government says that parents are expected to represent the best interests of the child in the process, but in fact many are actually not able to do that, especially in the stressful situations they find themselves in. So New Zealand First would have liked to have seen the fully funded government-funded counselling service to be reinstated before disputes mature. Not all families will break up if they get counselling in that way. Finally, the imposition of interest on legal aid. We think that will cause hardship. And serious hardship, which are the grounds for the legal aid agency setting aside the requirement to pay interest, is a very high bar, far too high, and low-income people will suffer. And 8%, Mr. Speaker, is simple government profiteering. Legal aid is paid for through taxation. The government should not be charging interest at all on funds from these sources for these public purposes. The state should make a contribution. Charging interest is objectionable and wrong in principle, and 8% is nothing less than disgusting as an approach to legal aid. The state is not a banker. It should be providing a public service. Mr. Speaker, for all these reasons, New Zealand First will certainly vote against this legislation.
I call Paul Foster-Bell.
Mr. Speaker, it's a pleasure to rise and take a brief call in this third